Good evening, ladies and gentlemen. I am honored to welcome you to the 52nd webinar of the first webinar series hosted by the Seminars Committee of the Bar Association of Sri Lanka for 2021-2022 on the topic Relevancy and Admissibility of Confessions. This webinar is conducted on the Zoom platform, and for those who have been unable to register on the Zoom, they could also join by watching the live stream on the YouTube channel of the Bar Association of Sri Lanka. So before we start, I would like to thank the Seminars Committee of the Bar Association of Sri Lanka, composed of the Chairman of the Seminars Committee, Mr. Rajiv Amarasuriya, Convener of the Seminars Committee, Assistant Secretary of the Bar Association of Sri Lanka, Mr. Pasindu Silva, and the co-conveners, Mr. Pandula Vanyarachchi, Mr. Oshan Uberatna, Ms. Anne Devananda, and Ms. Nikini Mapitigana. I would also like to take this opportunity to thank the President of the Bar Association of Sri Lanka, Mr. Salia Piris, President's Council, and the other members of the Management Committee of the Bar Association of Sri Lanka for all the support and the guidance. So, without a further ado, let me introduce the esteemed panel and the moderator for the day. It is with great pleasure I welcome Mr. Prasantala Alvis, President's Council, Honorable Consul General for Seychelles in Sri Lanka, and visiting lecturer, Faculty of Law, University of Colombo. A product of Ananda College, Colombo, Mr. Prasantalal De Alvis obtained his Bachelor of Laws and Masters in Law from the University of Colombo. It is 35 years since he was admitted and enrolled as an attorney at law. He was a state counsel of the Attorney General's Department for 7 years. He then joined the unofficial bar in the year 1991, and today he practices in the trial and appellate courts of Sri Lanka. Mr. De Alvis was appointed a President's Counsel in year 2012, and he was also the director at Sampath Bank PLC for 9 years and deputy chairman of Siapatha Finance PLC from the years 2011 to 2020. So he's also a senator of Junior Chamber International and also a certified national trainer. He is married to Mrs. Maheshi, attorney at law, and blessed with 2 sons, Vimukti and Abhishek. As it is brought to our attention that Mr. and Mrs. De Alvis are celebrating their 25th wedding anniversary today, I would like to convey heartiest wishes to you, sir, on behalf of the Bar Association of Sri Lanka and everyone who is present here. Our next esteemed panelist is Mr. Anura Maddegoda, President's Counsel and the Deputy President of the Bar Association of Sri Lanka. He served in the Attorney General's Department for 20 years and as a prosecuting trial attorney in the Office of the Prosecutor, International Criminal Tribunal in The Hague, the Netherlands. He is also a visiting lecturer in the Kotalawala Defence University. Our final panelist for the day is Dr. Visakesa Chandrasekaram. He has worked as a community law practitioner in Sri Lanka and Australia. He has also held the role of Deputy Director at the National Association of Community Legal Centres. He has also held various roles in the NSW Public Service, including in the Attorney General's Department and Police Force. Working as an independent art practitioner, Dr. Visakesa has written and presented several creative works, including the play Forbidden Area, the novel The King and the Assassin, and the feature films like Frangipani and Pangshu. He was also awarded a doctorate from the Australian National University for his research on the use of confessionary evidence under the counter-terrorism laws in Sri Lanka. So, And the moderator for this session for this evening, Mr. Asela Mutumudalige, LLB Honours Graduate from the Faculty of Law, University of Colombo, who has been practicing as a criminal counsel for the past 11 years. Before I hand over the proceedings to Mr. Asela, this is a note for all the members joining the session by Zoom. If you have any questions during this webinar, kindly share them in the Q&A chat box in the Zoom platform so that they can be directed to the esteemed panel by Mr. Asela. So I will now hand over the proceedings. Over to you, Mr. Asela.
Thank you very much for the nice introduction, Sasmini. We have come across through the 52nd webinar on law of evidence. Here we are here to discuss some vital areas of law of evidence. For your convenience, we have divided the topics into two categories. Firstly, we have relevancy of facts, and secondly, we have decided to discuss confession and its admissibility. So here we have a very distinguished senior legal practitioner with us, Mr. Prashantalal Dialvis, President's Counsel, also a senior visiting lecturer in University of Colombo. I welcome you on board, sir. As a beginning, if I may say, when conducting criminal trials, some judges, they are putting some question on us. There are some issues from us saying that, counsel, how does this evidence is relevant to your case? Or they might ask another question, how does this witness is relevant to your case? Obviously, the witness has to be relevant in the ways that are prescribed in the evidence ordinance. So we are privileged to have you here to educate us on this topic, sir. So we would like to invite you to educate on this topic, relevancy. Thank you. Over to you, sir.
Thank you, Asela. I hope me, Asela. Asela, you can hear me?
Yes, I can hear you, sir.
Right. So as the topic given to me is relevancy, as Asela pointed out, it is very interesting that a judge will ask always, what is relevancy? What is the relevance of this witness? So that's the area that I intend to speak. Now, if we take the whole scope of relevancy, it is found in the evidence ordinance. Now, we all know that evidence ordinance is applicable to both civil and criminal. And it's very interestingly, has all the examples or illustrations, both civil and criminal. But I must say it is most criminal you find in relevancy. Now, before coming to relevancy, I like to say the section that allows you to lead is section 5 ordinance. Section 5. What does it say? Simply it says that you can lead evidence only of fact in issue, only, I like to stress, and relevant facts hereinafter declared. I like to stress the word hereinafter declared. So we have fact in issue, and whatever declared hereinafter as relevant. So we have to limit ourselves to whatever hereinafter declared. That's the most important thing. Now, where do you find this? We find as a structure, part 1 of the evidence ordinance, which is section 1 to section 55, which is chapter 2. Now, that is a huge area on relevancy. It has from section 1 to 16 on basic relevancy. And that is an interesting area my colleagues in the webinar will speak to about confessions, which is from section 17 onwards. But Mr. Chandrasekharan and President's Counsel Mr. Maddegoda will cover that. So and that is the part relevancy. Now, what is fact in issue? Fact in issue is to very simply, in a criminal case, you have to prove the actus reus, the action that the accused committed this offense. And he had the required mens rea. What are the mens rea you find? Murder, hurt, you find intention, you find knowledge. And then in accidents and things like scenarios, you find rash and negligence. And then only section that we have is willful, is in section 3, not 8, as to cruelty of children. So this is the mens rea that you need to prove. But like the case of strict liability, the prosecution has to prove beyond reasonable doubt only the actus reus, like possession of heroin, that you carried a timber without a license, you possessed articles. Consumer Affairs Act, you removed the label. You were selling a product that was expired. Now that's actus reus. You need to prove those. Now, what is relevant fact? Basically, relevant is logic. I'll put it as logic. Logic and connect. And then comes, I like to stress at this point, some policy matters which connects with admissibility. Mr. Maddekoda, the President's Counsel, will discuss with you the admissibility of confessions. Of course, confession is relevant. It is relevant. Why not? Because you are confessing that you committed the offense. What more than that? But he will explain to you certain elements of admissibility. Admissibility is all about policy. I'll give you another example, section 120 of the Evidence Ordinance. However relevant they are, if it is the spouse, unless spouse is attacked or the child is attacked, you can't lead evidence. Why? To protect the marriage and to protect so that no one will give false evidence or you're compelled to give false evidence. I'll give you one example. So there is admissibility too. However it is relevant, how much you can argue, if it is not admissible, they will be brought forth. Now that's the introduction I like to have before you. Then I would take section 1 to 15. Now I like to break these sections. The last two, 14 and 15, are dealing with the mens rea, is dealing with the mind. What does this section 14 says? Any evidence that is of intention, knowledge, ill will, rashness, negligence, things like that I spoke of, all mental elements, and the feeling you get. Maybe I got pain when he hit me, bodily pain that you have to prove for. It's a bodily pain, it's a feeling. And in sexual cases, harassment is a feeling that you got annoyed, sexually harassed in section 345. Now, those are under section 14 of the Evidence Ordinance. 50 bit unique. It's also about the mindset. That is where about whether it is accidental. Whether it is accidental. And in the other alternative, whether it was intentional or it had a particular knowledge, a special knowledge. When there is a doubt like that, then evidence of system can be led. We call it system evidence. What is that? I just gave a very simple example. If there is a person who has killed a person, woman, his wife, to get insurance before us. So we like to see whether it was accidental or intentional. We have a doubt. But then it's a previous case, a similar case, similar exactly occurrence, something unique, which makes it system evidence. Same way Otherwise, you can't lead bad character of the accused. A previous incident cannot be led. So you lead system evidence to rebut an accident or there is a doubt. Now that's something very unique, something special. That is section 15. So 14 is mindset, mind. 15 also mind, but 15 is about mindset. So that is about the mind. Now let me take you through few elements of section 13, the rest of it. What is section 6? Section 6 is about the same transaction. So if there is evidence, I like inverted commas, same transaction, then you can lead that evidence. Now, I like to put you in a practical, very interesting scenario. Is there in illustration 1 or A? What is that? A is beating B, and there is a bystander. Bystander is not the one who is attacking the accused or the victim. He's a bystander, one who stays there. And he attacks. Whatever said or done by 3 of them, not only the person who attacked or the victim, even the bystander, like I am watching and I'm shouting, Prasantalal, Aselata Piheng and no. I'm just giving a very classical example. I'm a bystander. That is there. What there in the illustration is shortly before and shortly after. Shortly before and shortly after. Why we have this word? It is to prevent hearsay evidence. Otherwise, me, the bystander, right, you can't have a narration later. Narrator. It has to be shortly before or after, so that it becomes the same one and the same transaction. So it is truthful. But if you go, the same person, the bystander, narrating to somebody else, little later, is reporting. It is not spontaneity. There is no immediacy of the incident, so that it is truthful. So that's about the same transaction. Just to take in a line with the criminal procedure code, you know that charges of similar transaction can be joined together. That's the same purpose. If I kidnap a girl after that and kill, it can be added to the same charge sheet or the indictment. Now, that is exactly what here is. A kind of a concurrence, that whatever the same transaction can be laid under section 6. Now, that's what it is. Next comes section 7, which is very interesting. Cause and effect. What caused it? What affected it? Now, that's logic. You buy poison, you die. So what cause? Anything that is the cause of the action and the effect is there. If I commit adultery and the effect is adultery and ground for divorce. If I hit my wife, that causes cruel and inhuman treatment to her, that is a ground for divorce. So cause and effect. And the opportunity, now that's section 7. Whatever that gives opportunity to have that can be led under section 7. Again, I said before, all about logic. Third one, very interesting, is motive and preparation. Very simple, nothing big or nothing much to worry about. Now, then A2, right, motive or preparation is obvious. What motivated me killing, I said. Why? And preparation, I prepare poison, I prepare a gun. Those things can be led. prepare myself to commit adultery, that can be led. Then previous or subsequent conduct. This is very important. Anyone in a murder case, what is his previous conduct? How he behaved is very crucial to understand the offense of murder, offense of rape, how he was conducting, how he approached a girl, whether he had to have consensual sex with the girl. Now that is his previous conduct. Subsequent conduct was that. Those are the illustrations. He's run away from home. We as State Counsel, me and Mr. Madhagoda will lead evidence as a prosecutor to show that he evaded, absconded evidence. That will show his culpability. Previous or subsequent conduct in a divorce, that also shows culpability. So we can add on. So that's important. But the crucial thing in that explanation is that mere statement is not enough. The statement must be accompanied. What I say before, unless it explains my conduct. Because conduct is exactly what is apparent, what is truthful, and it is truth. So whatever I say, otherwise I can make stories, I can act, I can say anything, but you can't hide a conduct. So if it is a statement that makes the conduct, that is relevant under Section 8. Section 9 is which is there to necessary to explain or introduce, fix a time or a place, relationship of parties. Now, the classic case, we can at a question time, if there's any questions I can answer. It's all about, interesting case is Eliathambi Gabriel. Why I like this case is it demonstrates exactly what it is. Now, we will take the example. There is a man, woman who is drunk, wife is drunk, and man comes with his friend. And wife is saying, I'm having an affair with husband's friend. And thereafter she started sending letters. And what happens is the husband get hold of the letters. Now these letters are the ones that we are going to explain. The relationship. It went up to Privy Council. I will put it very, since the lack of time. There they decided, it overruled Sri Lankan, but they decided there, saying that it is admissible against the wife because it is she who wrote. So it is explains a fact, but it is not relevant because it is hearsay. Hearsay is whatever relevancy can be. But if it is not hearsay, if it is hearsay, what is hearsay? What you perceive by your five senses, the mouth, the nose, the eyes, the touch, what you hear, five, and your perception, your mind. Now, if that is not yours, it is not relevant. So, the court held that whatever letter that wrote to the friend, because he did not get it, if he got it and later found by the police, yes. Here, it was intercepted by the husband. They said, no, it is not admissible. So that's what it was held. So that's one case. There are so many which illustrates this interesting thing. Section 10 is basically very simply about a conspiracy. So that's about criminal. So anything said and done by the co-conspirators can be led to show only legal thing. What is that? There was a conspiracy. Simply that. And they took part. And that is all in Section 10. My dear friends, to sum up, I have this case, which sums up a very interesting Kokatattailaya. For anything, this is very crucial. What is that case? Case of Sathasivam, the famous cricketer in Sri Lanka. What happened was, Sathasivam went abroad, was coming home, and the wife feared that she will be killed. So she sent letters to the police, fearing her death, fearing death. Now, there, Section 11 says if you want to explain or to contradict a scenario, you can lead that evidence. Now, and with all the sections, it shows motive, it shows subsequent and previous conduct. All these sections are logically, technically in. But the court have very interesting one. Yes, there is trifling evidential value. Yes, they do. It shows anger, it shows apprehension, but the prejudicial value is more. So any case which there is relevancy, it can be relevant, but if it is a trifling weight and it is prejudicial in value is more, you can't lead. So that's a very interesting one. Can be relevant, but if it is prejudicial value is more, you can't lead. In section 11, I like to state here, one last point is about alibi. There is an illustration. The offense happened, it happened, and he was in Gaul. So he's in another place, and that's what we call alibi. Now that is contradicting under section 11, contradicting a fact in issue that he committed in Colombo, but he was in Gaul. But please remember, in year 2005, Act number 14 of the Criminal Procedure Code, new section was brought in 126A. Now there, I like to stress here, only applicable to the high courts. Only applicable to the high courts, not magistrate courts. That means normal offenders know that if you take up such a defense of alibi, you need to take it at the statement or at the non-summary inquiry. You know what non-summary is. The preliminary inquiry at the magistrate courts. That you have to take it. Or at least the last stage is 14 days before the trial to begin. You must say the place and the time. Why for that? So that the prosecution can get evidence. Prosecution get ready. You can't take suddenly alibi defense, which we normally took a long time ago before 2005. Now that's a point I like to stress here as far as alibi is concerned. So that's the scope and that's relevancy. And as I said, this Satasivam case gives a total case, however relevant, but if it is a trifling weight and the prejudicial weight is more than the evidential value, you can't lead. With that, Asela, I hand over to you. And I will wait for any question to answer on this.
Thank you very much, sir. Thank you very much for sharing your valuable knowledge and also your valuable time with us to educate us on the topic of relevancy. So, as Mr. Prasantalal Dialvis has concluded this session, we move on to our next topic, that is law of confessions. We have here a very distinguished senior lecturer from the University of Colombo, Faculty of Law, Dr. Visakesa Chandrasekaram. We welcome you on board, sir. So, Dr. Visakesa Chandrasekaram will deal with the theoretical aspect of law of confession, especially the relevant legal provisions in the evidence ordinance, also other written laws that are applicable to confessions. Because we have another expert with us to deal with the practical aspect of confession and the admissibility of the same. Without taking much time, I'm handing over the stage to you, sir. Over to you, to Dr. Visakesa Chandrasekaram.
Thank you very much indeed. I believe you all can hear me. If not, please let me know. It is wonderful to be here with you all today. Since I have been given only 19 minutes, I should actually straight away go into the topic that I have been allocated with. It takes a long time to talk about a topic like this, but let's try to focus on the key element that might be useful for the second speaker, Mr. Madde Goda, President Council, to continue. So, confessions are a type of admissions, as we all know, and they can be recorded by a police officer, by a magistrate, or judicial officer or non-judicial officer. Usually we see confessions being challenged, which are only recorded mostly by magistrates or the police officers. Section 127 of the Criminal Procedure Code allows recording of a confessional statement or any statement by a magistrate. Before going into that, actually, I would like to very briefly discuss the definition of a confession. So confession is a type of an admission made by the accused person. Section 17 of the Evidence Ordinance defines confession as in the following manner. Section 17.2, a confession is an admission made at any time by a person accused of an offense, stating or suggesting the inference that he committed the offense. So since it really does not pinpoint to the exact element of the confession, there have been some lack of clarity or ambiguity in the case law earlier, until this ambiguity has been resolved in Anandagoda case 62 NLR. In this case, there was an attempt made by the defense to establish that number of different admissions made by the accused person to the police in culmination constituted a confession. Number of different admissions, separate admissions made by the accused to the police in culmination constituted the confession. And doing so, arguing so, they were trying to secure an acquittal for the accused person in the Privy Council. And some of these admissions indicated the motive to to kill the victim, and the opportunity the accused person had to kill the victim, and the fact that he planned hiring a car and so forth, and the knowledge that the accused had where the victim's body could have been. All this in culmination formed the confession. So that is what argued on behalf of the defense. But actually the Privy Council rejected this argument and held there was no confession as such, simply because all the admissions in culmination created an idea, not even directly, but indirectly an idea the accused would have committed the offense. So this case is really important. If you go and read that in detail, it lays down a test to identify what is confession and what is not, a difference between a confession and an admission. Making his observations on this decision, Professor J.L. Peris gives another interpretation to identify a confession from an admission. He says, an admission to be treated as a confession, the statement must unequivocally establish guilt. The statement must unequivocally establish the guilt. And he added, in order for an admission to be considered as a confession, only if in intrinsic terms state or suggest the inference that the offense was committed by the accused. In intrinsic terms, state or suggest the inference that the accused committed the offense. So by including this term, intrinsic term, all the extrinsic matters are excluded from confessions. For example, if there are other statements recorded by the police or somebody else are available to pinpoint to certain facts mentioned in the confessionary statement, such extrinsic statements or external statements cannot be included when interpreting whether a particular document is confession or not. In simple terms, a confessionary document, confessionary statement should be self-contained. Section 127 of Criminal Code, subsection 3, allows a magistrate to record a confessionary statement or any statement when recording a statement, the magistrate must record it only if he has reason to believe that it was made voluntarily. Only if he has reason to believe that it was made voluntarily. In King versus Veerasamy case 43 NLR, the court held the law forbids a magistrate to record a confession unless he has reasons to believe that it was made voluntarily. So it is forbidden if it is not voluntary to record this confession. In recent time, 2019 case, Pradeep Master referred to Veerasamy case and reiterated the fact that the magistrate must be absolutely sure about the voluntariness. In fact, rather than simply asking whether the accused was making the statement voluntarily, magistrate should really probe into the details. Citing Gnanasiya Thero case, in this Pradeep Master case, it was held. Gnanasiya Thero case is really important in this regard because it actually presents the view of the court from the very progressive perspective, from the perspective of the accused person. So the court is very much concerned about protecting the right of the accused person who supposedly have given a confession in Gnanasiya Thero case. Now, there are two things that we have to understand and would be considered as necessary when a confession is brought against an accused person. The first thing is just to ensure this element of voluntariness, the court requires cooling off time. This is not a must, but most of the cases, both local and Indian cases, including Pradeep Master case 2019, the court did not use the term cooling off, but required a cooling off term, period. In that case, in the local case in Sri Lanka, it was held that when the accused has expressed his willingness to make a confession, at least 1 day should have been given to him to reflect on the repercussions of giving a confession. And there are Indian cases. Sometimes the cooling off time is a couple of hours, sometimes it is a couple of days. So there is no clear authority on cooling off time period, but the cooling off period is part of confessional law, so to speak, because it gives time after the accused was cautioned by the authority, let's say the magistrate, for the accused to think, should I give this confession if it is going to be used against me 1 day? So that is cooling off period. And the second element is corroboration. Now, if the confession is the only piece of evidence available against the accused, does it require to be corroborated? If confession is not the only evidence, probably this question of corroboration does not arise. But if the confession is the only evidence against the accused person, does it require to be corroborated? Now, you may know the mostly spoken of the case of Nallatha and Singarasa case, Nallathambi Singarasa case. In that case, it went up to the Human Rights Committee. It was held that corroboration, actually the corroboration was not questioned at all, which is very unfortunate. But subsequently, in 2000 case, Nagamani Devendran case, Supreme Court held that if the only evidence brought against the accused is the confession, that confession should be corroborated by independent evidence. So whatever written and mentioned in the confession itself is not enough if the confession has been retracted by the accused. If the accused in the court still admit that confession was given voluntarily, there is no problem at all. If the confession was retracted, if the voluntariness of the confession was retracted by the accused person in the trial, it is a requirement now that such confessions should be corroborated by independent evidence. Now, let's move into briefly about the admissibility of the confessions. I'm not going to go into details, but very briefly, what type of confessions are admitted in courts? According to the United States law or other English-speaking former Commonwealth countries, including Canada, Australia, New Zealand, the UK, confessions recorded by police officers can be brought as substantive piece of evidence. But in Sri Lanka, as we all know, confessions recorded by police officers cannot be brought as substantive piece of evidence, except in the case of Prevention of Terrorism Act, or PTA. Section 16.2 of PTA allows presenting proving of a confession recorded by a police officer against the accused. And also there is a change to the burden of proof in the Prevention of Terrorism Act. So Section 25 of Evidence Ordinance clearly says no confession made to a police officer shall be proved as against a person accused of any offense. So it's very clear. And also forest officers and excise officers. But Section 16.2 of PTA allows confessions recorded by a police officer about the rank of ASP can be brought as evidence and proved as evidence against the accused. Now, the second thing is, who has the burden of proving a confession against the accused? The burden of proving a confession against the accused is with the prosecution, of course, because the prosecution has to prove beyond reasonable doubt the offense. However, let's say, for example, an accused is retracting the confession, claiming that the confession was not given voluntarily at all. Then there is a question of who should prove that there was no inducement, promise, or threat in the confession on the accused person to confess. Now, something I missed in this regard, so that is actually Section 24 of the Evidence Ordinance. Section 24 of the Evidence Ordinance say, in order to be proved against a confession against an accused, that confession should have been recorded without any promise, inducement, or threat. And also it use of the word term appears. So I'll read that part of Section 24. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears. If the making of the confession appears to the court have been caused by any inducement, threat, or promise. Now, what this is really important to pay attention to the term appears as well as inducement, threat, or promise. So if there is inducement, threat, or promise, that means confession was not given voluntarily. But the term appears means it is not necessary to establish in absolute sense there is inducement, promise, or threat. If it appears to the court there is inducement, promise, or threat, that is adequate to consider that the confession was recorded without was recorded involuntarily. So, in other words, the accused did not voluntarily gave the confession, or in fact the accused might not have given a confession at all. The entire confession is fabricated. So if it appears to the court that the confession was given confession was caused by inducement, threat, or promise, such confession cannot be proved against the accused person. Now there is another issue in relation to burden of proof. Now, who has the burden of proof to establish whether the confession was given voluntarily or not? Now, interestingly enough, cases like Vivekanandan versus Sellaratnam and Queen versus Janasiya Thero establish the law that voluntariness of the confession should be proved by the prosecution, not by the defense, by the prosecution. Now, the degree of the proof is slightly disputed. It is not absolutely clear, but in many times it has been argued that the degree of the proof is also beyond reasonable doubt. However, when does it mean that the defense is completely free of burden of proving involuntariness on his side, or proving that the confession was recorded due to promise, inducement, or threat. No, the defense, yes, the defense is absolutely free of burden of proving according to Kumaraswamy. But having said that, even Kumaraswamy says the accused must present, or should, sorry, not, he doesn't use the term must, should present some evidence to establish the fact that the confession was not given voluntarily, or that confession was given due to threat, inducement, or promise. Now I'm running out of time. It has been 17 minutes already. So I think I have covered the basic elements of the law related to confessions from theoretical point of view. And there is one little thing available. If I mention that as well, it would be much easier for the next speaker to move on. So that is actually section 26. Section 26(1) of Evidence Ordinance says as follows. No confession made by any person whilst he is in custody of a police officer, unless it to be made in the immediate presence of a magistrate, shall be proved against such person. In simple terms, a confession recorded when the accused was in custody of the police officer or police officers, such confession cannot be proved against the accused person. Even so, the only type of allowance provided by the evidence ordinance is that the police may still be present at the magistrate chamber when the confession was recorded, but unless that, in any other time, if a confession was recorded in front of police officers, such confession cannot be proved against magistrate. There is an example for this, that is actually Polya versus Abegunwardana case. In this case, that confession was recorded by a government agent. Although section 26 was not discussed in detail, so one of the reasons for the court to reject that confession was the fact that the police officers were standing outside the government agent's office when he was recording the confession of this particular accused. So I think that's, my time is up, so that's all I can speak for today, but I think I covered the basic elements of the law of confessions. And then I would like to hand over back to Asela so our next speaker can talk about more practical aspects and elaborate on the details of this law. Thank you.
Thank you very much, Dr. Visakesa Chandrasekaram, for educating us regarding the theoretical aspect of law of confessions. Here we have a very distinguished senior legal practitioner with us to dealing with the practical aspect of confession, to discuss the topic of admissibility of confessions, Mr. Andro Maddegoda, Senior President's Counsel. Sir, as a senior member of the bar, also as a senior practitioner, you have could have come across with the numerous cases where the confession is admitted or not. So we would like to know from you, what is the practical way of admitting a confession, and also how it can be used in courts? Over to you, sir.
Thank you, Asela. Well, the two distinguished speakers before me, my learned friend Vasantalal, who is celebrating his silver wedding anniversary today, and we wish him well, and we wish him and his wife very well, and all the best in this today. And Dr. Chandrasekaram have dealt with certain aspects of the evidence ordinance. Now, the law of evidence, as you all know, is a very fascinating area of the law. This dates back to the 19th century, late 19th century, and it is a piece of legislation which has been in practice for well over, now we are now in the 21st century, from 1895 onwards, and it becomes even relevant today. Although it was introduced in enacted in 1895, the law of evidence as it stands today is very relevant. Of course, there have been certain amendments to the rules of evidence, and subject to those amendments, which have also been a development of the law as far as Sri Lanka is concerned, the evidence provisions of the evidence ordinance, as Prasantala very rightly pointed out, are applicable to both civil and criminal proceedings. Prasantala also dealt with provisions relating, provisions dealing with relevancy. So I do not, for example, I do not intend to touch on any of those matters, except to say that I certainly concur with all the views expressed by Mr. Prasantala, the Vice President's Council. And also thereafter we had Dr. Chandrasekaram giving us an exposition of the theoretical aspects of admissions and confessions. And in the course of it, Dr. Chandrasekaram dealt with the provisions of the evidence ordinance dealing with those matters. And I do not therefore intend to deal with them, except to say that my starting point is that section 24 of the evidence ordinance provides that a confession made by an accused person is irrelevant in criminal proceedings. If the confession, and it shows that it starts on the starting point is that a confession made to a person, it defines what a confession is. And thereafter, a confession that is made by way of inducement, threat, or promise, proceeding from a person in authority, or proceeding from another person in the presence of a person in authority, and which is sanctioned, will become certainly inadmissible. Also, section 25(1) rules out confessions made to persons in authority, police officers, excise officers, then other persons in authority, forest officers. So, as far as the law is concerned, any confession made to a person in authority is inadmissible, and that is a very salutary provision that has been brought in, because it has been found that confessions made to persons in authority are extracted by way of third degree methods. These are confessions do not have the voluntariness that is required of a person confessing to a crime. That in most instances, particularly in South Asian countries and also in Sri Lanka, time and again it has been established that these confessions are extracted by use of third degree methods. So for that reason, the Sri Lankan courts do not accept or admit any confessions made to a police officer. Of course, you must also at that point, we must bear in mind that there are certain exceptions. There are certain exceptions to the law. The exception to the law, as Dr. Chandrasekaram pointed out, is contained in the Prevention of Terrorism Act, where a confession made to a person, to a police officer, not below the rank of Assistant Superintendent of Police, becomes admissible. Of course, the prosecution, it must be a voluntary confession. When the defense takes up the position that it is not voluntary, it has not been made out of the free will of the person making the statement, making the confession. That there has been inducement, threat, or promise in the making of the confession. Then the court is required to conduct what is called a voir dire inquiry. Voir dire inquiry is an inquiry within an inquiry. And that inquiry is conducted to ascertain whether the statement that is sought to be proved the statement that is sought to be proved by the maker of the statement, which constitutes the confession, has been made voluntarily. So, for that purpose, the prosecution then, as rightly pointed out by Dr. Chandrasekharan, these are all matters that the prosecution, the burden of proof is on the prosecution. The prosecution has to establish or discharge their burden of proof beyond reasonable doubt. There is nothing short of that. So, in discharging their burden, the prosecution is required to prove that the statement was made voluntarily. Now, there are instances where wider inquiries, where particularly cases brought under the Prevention of Terrorism Act, and prior to that, there were the emergency regulations. Prasantalal will remember when he and I were both in the Attorney General's department, there was the ER section and the TR section. All the emergency regulations cases also had the flare of confessions that were brought in, confessions made to police officers above the rank of Assistant Superintendent of Police. And again, in those cases, also wider inquiries were held. Now, in such instances, it has to be established that the maker of the statement had time to think about the statement. Dr. Chandrasekharan described what is called as a cooling off period. And that the person who appeared before the Assistant Superintendent of Police or a man above the rank, police officer above the rank of Assistant Superintendent of Police, when he is taken into the office of the ASP or the SP or the DIG, he is taken from custody. He is taken either from the CID or from custody. Now, in that the police officer, the senior police officer is told that the maker of the statement wishes to confess to the crime, wishes to make a statement, a voluntary statement about his participation, about his involvement in the crime, in the offense. So at that point in time, the Assistant Superintendent of Police or the officer, the senior officer, is required to ascertain from the maker, from the person who is produced before him, whether he is making the statement voluntarily, whether there has been an inducement, threat, or promise for him to make the statement. Has there been an inducement, threat, or has the police promised him that he will be released from custody? Have they promised him that he will be immune from prosecution? That no proceedings will be launched, will be initiated against him? That he will be made a witness in a case? So those are the types of promises that are made to persuade suspects to make confessions. So the senior officer must satisfy himself that the person who wishes to make a statement, or the person who is brought before him, who is intending to make a statement, is himself making it voluntary. So the cooling off periods comes into play there, and then he must be asked to go back to reflect on what he has told the senior officer. He can come back the next day. He can again come back a second day. The senior officer can again ask him, okay, go back. Have you thought about it? Have you thought about the implications arising from this? And then, upon being satisfied, then the senior officer has to take down the statement. Now, we use the word recording a statement, but the word recording a statement is not used in the English jurisdiction. It is what is called a taking a statement. Recording, if you in the very English jurisdiction, if you say it is the police officer record a statement, if I has recorded a statement, the lawyers will say, okay, let me see the tape recording version of the statement. It is actually the taking of a statement. Even in the international jurisdiction, in the International Criminal Tribunal, it is always a taking of a statement. And that statement is a statement in writing. So when the police officer takes down the statement, he has to make sure he will only have before him the typist to record who will take down the statement, who will type the statement. Or if it's in a computer, the data entry operator or whoever who will take the statement. No other person is required. And at the time the person is brought before the police officer, the police must maintain a timeline of events from the first day onwards till the making of the statement is concluded. That is brought before the senior officer at this time. The date and time has to be taken, has to be noted. There has to be certain intervals between the making of the statement. The suspect or the detainee should be given breaks, should be given whatever break he requires, a lunch break, a tea break, should be given a refreshment if he so desires. And sometimes there are statements that are taken down over several days. Recently, I had a case where a statement was taken by a senior superintendent of police. Now, at the time the indictment was served on me, the relevant information book extracts with regard to the taking of the statement were not served on me. I insisted that the prosecution must serve those documents on me. When I examined those documents very closely, I found that what has been explained to the suspect is incorrect. The legal provision of it, that there was no continuity in the statement. That statement that has been taken contained changes that have been made, which have not been initialed both by the suspect and by the senior officer taking the statement. That also that the suspect or the detainee has not been, the changes have not been explained to the suspect or the detainee for him to further clarify an issue. So those are all matters that we will find in the information book extracts, and as practicing lawyers, we must bear in mind that particularly in PTA cases, which some of them still continue, that we must insist that the prosecution serves on us all information book extracts relevant to the making of the confession of the statement. So that is a document that is listed on the indictment, what is called the Sakakaru Vittikaru or Sakakaru Vittikaru Papocharane, Sahakara Police Adhikari Papocharane, or the confession made to the Assistant Superintendent of Police. And we have to insist that those relevant information book extracts are all given to us. It is only then can be successfully and effectively formulate a defense on behalf of a client. There is also another exception to this rule, that is Section 27(1) of the Evidence Ordinance. Section 27(1) of the Evidence Ordinance. A person, there are certain discoveries that are made consequent to a statement that is made. If I can just very briefly, I will read Section 27(1) of the Evidence Ordinance for the benefit of the young lawyers who may be participating in this webinar. Section 27(1) says that provided that any fact, I'm reading from the section, provided that any fact, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense. So the relevant words are, when any fact is discovered as discovered in consequence of information received from a person accused of an offense in the custody of a police officer, so much of some information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered may be proved. Assuming that in the course of the statement, the suspect, in a statement to the police, the suspect will say that the weapon that was used to stab Bapu Ami was hidden under the banana cultivation or the banana tree. So the police officer will make that according or consequent to that statement, the police officer is required to accompany the accused or the suspect to the shrub jungle or to wherever it is, wherever he says it can be, I have hidden it inside an Almira, I have hidden it in the shrub, I have hidden it behind my house, whatever the statement that is made, the police officer will accompany the suspect. And the suspect is required to point out to the police officer the place at which the item that was used for the commission of the offense, the weapon or the that was used for the offense is concealed. Now, upon pointing out that place, the police officer is required to grope that area and see whether there is a firearm that has been concealed or hidden, whether there is a knife, whether there is a club or whatever, and he is required to take it out from that place of concealment. Now, that portion of that evidence, if the police finds a knife or a firearm in consequence of that statement, then that evidence becomes admissible in a court of law. And what becomes admissible from the suspect's statement is that sentence which says, I can point out the place where the firearm was hidden. I can point out the place, I can show you the shrub jungle where the club was hidden. Now that portion of the statement becomes admissible. So that is an exception to the rule of the confession to a police officer not being admissible. There are numbers, there have been, throughout history, in the time we did prosecutions, there are cases we have done, umpteen number of cases where the police officer will then, in consequence of the offense, we lead that evidence as prosecutors, where the discovery of a weapon. Now there is a subtle distinction there also with section 8.2. That was the part that my friend Prasantalal dealt with. Section 8.2 we deals with what is called subsequent conduct of an accused. Now subsequent conduct, the accused will also say, I can take you to the shrub, and he takes him to the shrub and he goes there and he will take the knife and hand over the knife to the police officer. If he hands it over from inside the shrub or from inside the box or from inside the toolbox that was used where if he used a cathy, then that is not admissible under section 27, but that becomes admissible as part of subsequent conduct of an accused. Now that is an area where I see lots of practicing lawyers, particularly and also both from the official bar as well as from the unofficial bar, making the mistake of attempting to admit section 8.2 evidence as section 27.1 evidence. So we must bear that in mind as practitioners. We must always bear that in mind and make sure that we know the distinction between section 27.1 and section 8.2 of the evidence ordinance. Then again, going back to the voir dire inquiry, in the voir dire inquiry, there is a burden of proof on the defense as well. That is not as high as the burden of proof that is on the prosecution, but that is a burden of proof on a balance of probability. Then Dr. Chandrasekaram also dealt with confessions that are made to magistrates, so that is quite simple. I mean, I'm not going to go through the provisions of section 127 of the evidence ordinance. And even there, the magistrate, when a confession made to a magistrate is to be laid in evidence, the prosecutor is required to summon the magistrate to testify. And there are instances where magistrates are subject to cross-examination, and lawyers will put questions to the magistrate in order to establish that this confession was not made voluntarily. There have been instances, and I remember when I was prosecuting in the Anuradhapura High Court before the late Mr. Nespit Abevera, who was then judge of the High Court, a confession that was taken by a magistrate was the judge, in fact, refused to admit that confession because it was the evidence of the magistrate was impeached very seriously. And the trial judge, in his wisdom, decided not to admit that confession. So, as far as the practical aspects of confessions, but the most cardinal principle we need to bear in mind is that no confession made to a person in authority or emanating from a person in authority is admissible. And that is due to the fact that there have been, the courts have considered that it is unsafe to place reliance on confessions made to persons in authority, because it has been proved time and again that third-degree methods have been used. So, subject to that, then there is the section 27(1), as I told you. There are confessions that are made to police officers not below the rank of assistant superintendent of police, and there is what is called the voluntariness of the confession has to be pronounced upon by the court, for which purpose there is a voir dire inquiry, an inquiry within an inquiry, and the court is then required to determine the voluntariness of the inquiry of the confession. Also, in determining, there is also, with regard to Dr. Chandrasekharan, also referred to aspects of corroboration that is required. If the confession is the only item of evidence that is available, there are cases where the prosecution will rely only on the confession that was made to a police officer, to a senior police officer above the rank of assistant superintendent of police. Now, in that context, once the confession of the police officer recorded taken by the police officer is eliminated, is rejected, then, of course, that becomes the end of the prosecution case. So, when there is only that confession, the prosecution must rely on other material items of evidence to establish the voluntariness of the confession. As defense counsel, we have to ensure that we are served with all those documents that are listed on the back of the indictment. There are witnesses who are listed on the back of the indictment. Each one of them may have played a role in taking down the confession, in the making of the confession by the suspect. So we have, as defense counsel, have to ensure that that the accused is served with all the documents pertaining to the making of that confession. There may be also documents that are not listed. It is up to us to be so diligent as to ensure that we ask for. If we can find that there is reference to some other document which is not listed, we have the right to ask for the documents that are not listed, because in the interest of a right to a fair trial. So those are the matters. I think now the time is almost gone up to 6:45. So, and I believe Asela must be also wanting to put questions from the other participants of the webinar. So I will, for the time being, I will rest my presentation, and unless there is any other matter that needs to be clarified, and if any questions have to be answered, I'm available. So with those comments, Asela, I will hand you I'll revert to you so that you could continue for the next whatever little time that is left of this webinar. Thank you.
Thank you very much, sir, for sharing your vast experience and knowledge with regard to the practical aspect of confession, also its admissibility. So here we now move on to our questions from the audience. We have another question from audience. I will put this question to Senior President's Counsel, Mr. Andra Mathegoda. So, sir, one question here. A confession made to a friend, can it be admissible under our law, and how the prosecution can lead evidence on such? That is the question that I have been asked. So I wish to put that question to you, sir.
Can you repeat that question, Asela? Confession made to a
friend, whether it is available, admissible under our law.
Confession made to a friend. So let us say that the example that was given of Asela being an attack on Asela, right? Somebody tells me that yes, a friend of mine says, yes, I attacked Asela and I was there, or I was present. Or somebody makes a confession like that to me, whether I can be called as a witness.
Yes, that is the question, I think. That is the question I think they ask.
Certainly I can be called as a witness, and certainly I'm not a person in authority. So as if I was a bystander, or if I was another person who saw this incident, certainly the statement that is made, the confession that is made by the assailant to me becomes admissible in evidence. There is no way that evidence can be dismissed or rejected. And I can certainly say that the man who assaulted the dead person, in fact, having done that, did tell me that I was the one who attacked the dead person or the injured person. And I am a competent and a compellable witness to that incident. I hope I got that answer.
Yes,
Question
thank you,
correctly.
sir. Thank you. We have another, actually, it's a reference that we have been asked by one of our audience members. The Sathasivam case reference that has been asked, I wish to get it from Dr. Chandrasekaran. Sir, are you online?
Yes, and I'm just searching for that. I'll just send that. I'll post it on the chat box.
Thank you very much.
Okay.
So it seems that we have reached only those two questions from the audience. No, we have another question. The question says, a question from Azwar. How far our evidence law recognize computer evidence? So I wish to put this question to Senior President Counsel, Mr. Prasantalal Dialvis. Sir, can you give an answer for this?
Yes, evidence was brought in by the Evidence Ordinance Special Provision Act. Earlier, like computer evidence, if it's a document, we could not lead it because there is an issue of primary and secondary. Now, if it is computer evidence, it is fully covered by the Evidence Ordinance Special Provision Act. There is, I think section 5, 5, which covers the entire computer evidence. But I like to stress at this point of time, electronic Transaction Act. There, the Evidence Ordinance Special Provision and the Evidence Ordinance have been taken away. Like Computer Crimes Act also, the Evidence Ordinance Act is taken away. So that kind of giving 45 days notice before it is given is not necessary. And computer evidence also, evidence of affidavit is sufficient. Affidavit by the person who handled the computer is sufficient, unlike he need not come to courts. So we can lead computer evidence under the Evidence Ordinance Special Provision Act, where only affidavit is evidence and notice of 45 days is required. But if it is an electronic transaction, unfortunately, those safeguards have been taken away.
I believe, Sathasivam, I believe is 55 NLR.
Yes, shall I give it?
Yes,
55 NLR 235, am I right? Or 255?
Exactly. 55 NLR 255.
I see. Okay.
55
Sorry
NLR
about
255.
Yes, sorry
Yes,
about
55
that.
NLR
I think there are more than one Sathasivam case because there was some clarification requested from the Supreme Court as such.
I refer to is 25 NLR. Like Mr. Madhaguda said, 255.
Thank you, sir. We have another question from Sampath Pereira, attorney at law, I think. How is the voir dire is conducted under jury trial? So I wish to put this question to President's Counsel under Maddegoda. Sir, we are hoping a reply for this question. Why die under jury trial?
Why die under jury trial?
How is the
Now-
voir dire is conducted under the jury trial? That is the question, sir.
Now, at the time, the jury trial, certainly, I must confess now, jury trial, which is jury trials or trials we had during the time Prasantalal and I were in the prosecution. And also, I believe Prasantalal in the defense himself would have conducted jury trials defending an accused. But nowadays, jury trials are certainly, you don't see, are not the order of the day. In fact, I had one jury trial in Jampa, but later on, then the accused again pleaded guilty to the charge and there was no jury trial. So, as far as jury trials are concerned, I believe the provisions will be the same. If you are charged now, there won't be a PTA charge, won't come up before the jury. That is the first point we have to bear in mind. Because the jury trials were held only in respect of charges of murder, attempted murder, and rape. Hello?
Yes, sir. Yes, we
Hello?
can hear you, sir.
Can I be heard?
Yes, sir, we can hear you.
Yeah, jury trials were in respect of charges of murder, attempted murder, and rape. So there were no jury trials with regard under the PTA. There are no jury trials. So, but in the event that there is a voir dire inquiry in the jury trial, then the voir dire inquiry will also have to be conducted in the presence of the jury, because it is the jury who will make a finding of fact. The finders of fact, the persons who decide on the facts of the matter, will be the jury. The judge will only direct the jury with regard to the law. That is all. The role of the judge is to direct the jury with regard to the law. On matters of fact, it is the jury and jury alone that can come to a finding. And there, in coming to a finding, it must be an acceptable verdict. It must be either a unanimous verdict or a verdict of 6-1 or 5-2. A verdict of 4-3 is not an acceptable verdict, but then what happens is, if the jury returns with a 4-3 verdict, the judge will ask the jury to reconsider that verdict. We'll tell them, please go back and reconsider your verdict. So it is a unanimous or a 7-1 or a 5-2 verdict that is considered an acceptable verdict. Thank you
very much, sir. We have another question connected to the first question that was asked by myself. When a confession is made to a friend and the friend is called to give evidence, does it amount to hearsay evidence? I think Mr. Prasantalal always can answer this question.
Yes, sir.
Did you get the question, sir?
Yes, Asil. And this is very simple. Hearsay is what you have seen, what you have perceived from your 5 senses. Now we are leading confession. Now we will give an example like I kill Asela and I tell my friend that I kill Asela, like what Mr. Maddegoda said. So what my friend is now hearing is what I said from his own ears. So it is not hearsay. What he is saying is that Prasantalal said that he killed Asela. So that is not hearsay, because that is exactly what he had perceived from his 5 senses, what he had experienced himself. So it is not hearsay, Asela.
Thank you very much, sir. We have another question, that is whether the SMS can be considered as evidence. So I wish to put this question to Mr. Andra Maddegoda, President's Counsel.
Yes, Asel, I will certainly argue that SMS is evidence. There is no question of that. Unfortunately, I have still not come across a situation where I had to rely on SMS evidence. And also at the same time, I must say, if I have to leave that evidence, but if I am opposing that evidence, I will still also argue that the SMS is not admissible evidence. And for the reason that I will argue that in terms of the Special Provisions Act, that I need to examine the device that was used to generate the short message, the SMS, the short message service. So without having had the opportunity of examining the device, I will argue that that evidence is inadmissible.
May I add Asela to Mr. Maddegoda?
Yes, sir.
There is a judgment of a commercial high court by Justice Tilakarsiri when he was a high court judge, saying that a SMC is evidence, but it never went to a court of appeal to become a, because it's a trial court, it has never become a thing. It is not becoming a kind of judgment from a higher apex court. So it is not that way sense, but then there is a judgment to say that SMS is evidence by a judgment of Justice Tisasri when he was High Court judge.
Yeah, I remember that judgment. I remember that evidence that was being laid, and the High Court accepted that evidence.
Exactly, Mr. Mandel.
Yeah. Of course, unfortunately, never went up in appeal.
Yes.
For there to be a appellate court pronouncement on that, but the High Court did justice. Yeah, that's right.
Thank you very much, sir. So I think we have answered for all the questions that were in the chat box. So it is almost 6:56, time to wrap up the session. Before wrapping up, I would like to thank all the expert panelists who have contributed their time and valuable knowledge for this session on law of evidence, especially that we have discussed the topic of relevancy and also the admissibility of confessions. So I would like to thank Mr. Prashantalal Alvis, Senior President Counsel, also Mr. Andrew Maddegoda, who is also Senior President Counsel, and Dr. Visakesa Chandrasekaram, a Senior Lecturer of the Faculty of Law, University of Colombo. Also, I wish to take this opportunity to thank the seminar committee of the Bar Association of Sri Lanka, especially the chairman, Mr. Rajiv Amarasuri, Attorney at Law, Secretary of Bar Association. Also to the team, that convenient team of the Bar Association, who has given support to make this discussion as a fruitful discussion. So I will wrap up with that. I will hand over the stage to Sasmini. Over to you, Sasmini.
Thank you, Mr. Asela. So on behalf of the Bar Association of Sri Lanka and Seminars Committee, I would like to thank Mr. Prasantalal Alvis, President's Counsel, Mr. Anura Maddegoda, President's Counsel, Dr. Visakesa Chandrasekaram, and of course, Mr. Asela Mudumuthalige for this very informative and valuable session. I would also like to thank all those who have joined us today through Zoom and YouTube for your participation and also the questions that you have made that made this webinar an interesting one. So thank you everyone for joining us today. So join us again next week on Saturday at 5 p.m. for the 53rd webinar in this series on a very different topic. Stay safe, everyone.
Thank you.
Thank you, Sasmini. Thank you. Thank you, Asela.
Thank you, Sashini, and thank you, Asela.
Thank you very much, sir.
Thank you very much, sir.